Hello everyone, and welcome to today's video. In this episode, we're going to look at a few different individuals who identify as sovereign citizens, and we'll follow what happens during several of their court appearances. These cases show some of the unusual arguments people sometimes bring into the courtroom and how the legal system responds to them. Our first stop is in Michigan. Here, we see someone who appears to claim they are an American state national. They attempt to use a common argument that separates their living self from a legal identity connected to their name. According to their claim, the loan was supposedly given to that legal identity, not to them personally, so they believe they should not be responsible for paying it back. This type of argument has appeared in courts many times before, and it often leads to some very interesting exchanges with judges. So with that background in mind, let's jump in and see how this situation unfolds.
All right, this is 23014058 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared, and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm...
No, we had a hearing on, maybe. I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
This situation actually brings to mind another unusual case from the past. In that instance, a self-proclaimed sovereign citizen tried to request subpoenas for every registered voter in Harris County. Considering that the county has around 5 million voters, the request was extremely unrealistic and quickly raised eyebrows in the courtroom. Unsurprisingly, the court did not approve that request. It simply wasn't practical or relevant to the case being discussed, and the judge made it clear that the legal system can't be used in that way. In a similar fashion, the person in this case is now asking for full accounting records from Chase Bank. However, just like the earlier example, the court is expected to reject this request as well. Judges typically limit access to information that is directly connected to the case, so broad demands for massive amounts of data rarely move forward.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owed $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
Like that's why I asked questions, Your Honor. You know, you say you gave them 10 days to send it to me. They didn't send it to me. I just got an
But
email
Mr.
this morning.
Chavez, you're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those
So,
are the questions.
okay, my defense is I am the lender and they borrowed from me.
What he's saying here really shows a deep misunderstanding of how credit and banking actually work. His explanation doesn't line up with basic financial reality, and it quickly reveals the kind of belief system he's following. People who hold these views often identify with the sovereign citizen movement. Some even claim to be something called an American state national. A common idea within that group is the belief that whenever someone opens a line of credit, the U.S. government secretly places money into the bank behind the scenes. According to this theory, the bank supposedly receives funds from the government the moment the credit is issued. Because of that belief, they think the debt has already been covered in some hidden way. When the bill finally arrives, they often claim they can simply cancel or discharge the debt using funds from a supposed secret account tied to their name. Of course, courts and financial institutions repeatedly explain that no such hidden accounts exist, and these claims don't hold up when examined under real banking rules.
What did they borrow from you?
My personal security, which I'm
No,
entitled to
there,
rights to.
no, I'm not buying that. No. Listen
Okay.
to me. You listen.
It's not about. I have it. This. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You
Is
took
that-
a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card. And you didn't pay on the card. They don't owe you anything.
So So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. Where did I? 1 second here. I have them.
No, wait a minute. December 19th, you're the problem.
Okay. It's gonna have to be January 9th.
Okay,
My clerk's indicating.
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set.
All right, so this case is almost finished at this point. The court has scheduled a hearing for the motion for summary disposition on January 9th, which will likely determine the final outcome. When that hearing takes place, I'll make sure to bring you the updates and explain what happens next. Now, before we move on to the next situation, there's something else worth mentioning. This same individual actually showed up again on the court docket for a very similar issue. In fact, it's nearly the exact same type of case, just involving a different credit card company. So instead of resolving the problem the first time, he appears to have repeated the same approach with another lender. As you might expect, the court will likely treat this second case in a very similar way.
I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
When a court considers reopening a motion that has already been decided, especially when one side was not present at the original hearing, it can sometimes allow what is basically a second chance to address the issue. This situation often comes up when the missing party is representing themselves in court. However, the court will only allow this kind of redo if two important conditions are met. The first requirement is having a legitimate reason for missing the original hearing. In this case, the hearing was held over Zoom, and the person claims their internet connection failed. From the court's perspective, a technical issue like that can be accepted as a reasonable explanation. The second requirement is something called a meritorious defense. This means the person must present a solid legal argument or meaningful evidence that could realistically help them win the case. In other words, there needs to be something substantial for the court to consider. Simply saying you want another opportunity to go through the process again is not enough. The court needs to see that there is an actual legal point or piece of evidence that could make a difference in the outcome of the case. Without that, the request to revisit the hearing usually won't be approved.
Okay. All right. Here's what we're going to do. I'm setting a date. So what do we need discovery on this? Mr. Goethals, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay. And the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
It's possible he spent a lot of time preparing his affidavits and documents, thinking they would strengthen his position. But it also seems like he may have missed an important point the judge already explained during the hearing. The key issue is that he had already submitted his formal response to the case. In that response, he did not actually challenge or deny the main claims made by the plaintiff. When that happens, the court generally treats those claims as uncontested, which makes it much easier for the judge to rule in favor of the other side. Because the claims weren't properly disputed, the judge had enough legal basis to make a decision against him. Courts rely heavily on the written responses filed in the case, and those documents play a major role in determining the outcome. And regarding his request for due process, he did receive it. The court gave him the opportunity to file responses, present arguments, and participate in the legal process. Once those steps are provided, the court considers that the requirement for due process has been fully met.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim. And
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29 will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set.
And with that, we wrap up that part of the case. The response from the court was clear, and the process played out exactly the way the legal system is designed to work. At the end of the day, the judge reviewed the filings, considered the arguments, and made a decision based on the rules of the court. Now it's time to move on to the next individual in today's video. This person also claims to follow the same sovereign citizen ideas, and he's about to face an important moment during a formal hearing. Interestingly, this is a hearing that he personally requested. However, things quickly take a turn when he refuses to properly identify himself in front of the court. As you can imagine, that decision creates immediate problems. Courts require basic identification to confirm who is participating in the case, and when someone refuses to provide it, the situation usually doesn't go in their favor. Let's take a look at how this next courtroom exchange unfolds.
All right, we're all set. Thank
I
you,
don't have
Mr.
no words.
Mr. Arnold, I ruled against you.
I have
am allowed
evidence.
to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
Mr. Moore, you can come forward, sir. Yeah. Oh. Okay. Are you Sherman Moore?
I am not.
You're not. Okay. And so are you appearing on Mr. Moore's behalf?
Yes,
Okay.
I am yes, here for that matter to handle the matter that's at hand.
Okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay, so you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as a beneficiary executive for the said name.
Earlier, you mentioned that you were present in court on behalf of the defendant and even suggested that you were acting as his lawyer. That's a serious claim to make in a courtroom setting, and it immediately raises an important question. As you probably know, representing someone in court requires proper legal authorization. Attorneys must be licensed to practice law and must have a valid bar number that allows them to appear in court on someone else's behalf. Without that credential, a person cannot legally act as a lawyer for another individual. Courts are very strict about this rule because it protects the integrity of the legal process and ensures that representation is handled by qualified professionals. So if someone claims to be speaking for the defendant as their attorney, the court will expect proof that they are actually licensed to do so. Without that verification, the court typically will not allow them to continue in that role.
Okay, before I respond, let me see if the city takes any position. Mr. Gunderson, is the city taking any position on the representation of Mr. Moore in this matter? I don't even know if you're appearing on behalf of the city in this matter.
Good morning, Your Honor. Will Gunderson, prosecuting for the city. Your Honor, the city does typically appear for the contested hearings in which officers have been subpoenaed.
Was an officer subpoenaed in this matter?
Yes. Your Honor, the officer is present. Officer Berglund is here. Your Honor, my position at this point is to request a short continuance in this case. The basis being I rely on the Judicial Information System, or JABS, review that information relevant to the particular case. Within the last 20 minutes, JABS database has gone down. Oh.
And do
now.
Do you take a position on the representative of Mr. Moore appearing in his stead this morning for purposes of the hearing?
Your Honor, ultimately the city would defer to the court on whether or not the individual is present is allowed to act on behalf of the defendant. To cut to the chase, Your Honor, this sounds like it might be a sovereign citizen type of situation. I don't know if the individual that is seated here is in fact the defendant, or if he is a completely separate person, separate and apart from the defendant that was pulled over at the time this incident took place. So that is a red flag, so to speak, or a question mark that does get raised in the city's mind, for which the city does believe that a further inquiry by the court may be appropriate. But ultimately, Your Honor, with regards to any representation, city will defer to the court.
All right, thank you, Mr. Gunderson. So, sir, I'm going to ask you to identify yourself for the record, please.
I am one of the people.
I'm sorry?
One of the people.
Okay. Are you, or have you been previously named or identified by the state of Washington as Sherman Moore?
I am not Sherman Moore,
Okay.
the entity in which you speak of.
Okay. And do you have any relationship to Sherman Moore?
I am just the beneficiary of that name.
So let me see if I understand the idea you're putting forward. According to your argument, you would receive all the benefits connected to that name, like if money were won in a lottery or some other reward came along. But when it comes to responsibility or legal consequences tied to that same name, suddenly that connection doesn't apply. In other words, the advantages belong to you, but the obligations somehow don't. When you look at it that way, it would certainly make life very convenient if things actually worked like that. Being able to claim the benefits while avoiding the responsibilities would be quite a setup. Of course, the legal system doesn't operate that way. In the real world, rights and responsibilities are connected, and you can't separate them just to keep the good parts while ignoring the rest.
Well, the problem that we have here is that at this point, based upon the record that I have before me, sir, you are not authorized to represent Mr. Moore as an attorney in this matter because you are not a licensed attorney by the state of Washington. And at this point in time, based on the record, Mr. Moore has not appeared in...
Oh, he's right here, sir. Sherman Moore is right here. The name in which you speak, he's right here, sir.
Well, that, for the record, you're holding up a piece of paper.
Yes, the document, Sherman Moore, the entity in which you speak of, and one in which you tend, or this court intends to charge. So I am just the beneficiary of said entity. That is all. And that's why I'm here. So basically, I'm trying to find out the nature of said charges that pertain to said name.
Sure, certainly.
Is this a criminal or a civil matter is what I'm trying to figure out here, sir.
This is a civil matter. So Sherman Moore, or an individual identified as Sherman Moore, was issued an infraction here in the city of Lakewood on September 5th, 2024, and was ordered to respond to the issuance of that infraction, which it appears that he did, and requested a contested hearing in which he is asking to challenge the evidentiary sufficiency of the information relied upon by the issuing officer who issued the infractions or the issuance of those infractions. But by requesting that hearing, Mr. Moore, or the individual who was issued the infraction named Sherman Moore, indicated that he would appear in person as a living person here in court. And the problem that I have at this point in time is that based upon the record that I have before the court, Mr. Moore has not appeared as a living, breathing human being in this court in response to his request for a hearing.
I am simply just a man on the land that is here on behalf of that name as the beneficiary for that name.
I understand that. But at this point,
There's a claim being made. So therefore, like I said, I'm just here to understand the nature. You say it's a civil, so where is the verified complainant for said charges?
At this point, the prosecutor has already made their presence known in the courtroom, and the police officer who was subpoenaed is also there, sitting nearby. So if you're searching for the official parties involved in the case, they're already right in front of you. In other words, the people who filed the complaint aren't hiding anywhere. They're sitting in the courtroom, just a few seats away. There's no need to look any further or request additional identification. The court makes it clear that the verified parties are present and accounted for, so anyone trying to avoid acknowledging them or locate them elsewhere is essentially wasting their time. Everything needed to proceed with the case is already in plain view.
the verified complainant is the city of Lakewood, represented by the attorney on behalf of the city, who is seated in the courtroom to your left, appearing down to my right. And Mr. Gunderson, I'm just going to ask you to formally identify yourself for the record.
Thank you, Your Honor. Will Gunderson, prosecuting for the city. I am licensed to practice law in the state of Washington. My bar number is 46991.
So the plaintiff in this case is the city of Lakewood. They are appearing here this morning through counsel, or this afternoon through counsel. It also appears that the officer who issued the infraction to Mr. Moore is also present in court in response to the subpoena that was issued for his appearance. It appears that the only individual who has failed to appear for this hearing is the respondent, Sherman Moore. And so at this point in time, with the matter having been on the calendar at 10:30 a.m., it's now 12:04 p.m. Given that Mr. Sherman Moore has not appeared in person for this hearing, pursuant to the rules for infractions in Washington courts, the court will find that Mr. Moore has failed to appear and will enter a finding of committed to each of the 5 infractions. And I believe that concludes our court's calendar for today. So thank you all very much. At this point in time, the court will be at recess.
Understood, Judge.
Oh yeah, I'll do it in the, yep.
All right. Court is in recess.
Who would have guessed that simply failing to properly appear for your own court date would almost guarantee a loss? It seems obvious, but some people still try to test the system, and this is what happens when they do. The funniest part comes right after the judge finishes the hearing and leaves the courtroom. That's when the sovereign citizen finally has a moment of realization. He suddenly understands that he just went through a classic play around and find out scenario, and he found out the hard way. It's a clear reminder that the court takes attendance and participation seriously. Showing up, following procedure, and responding to the claims against you aren't optional. They're essential if you want a fair chance to defend yourself.
So, are we continuing or what's? Based off of what grounds or what?
Mr. Moore did not.
Sherman Moore is here. I am the man of the Moore, Sherman of the Moore family. I am not the entity in which you speak of. What? kind of charade show is going on here? So what happens now? I have to file an appeal? Okay. So I'm being railroaded. So the officer never had to show or anything, basically on the basis that so the witness or the subpoena I never got to cross-examine.
No, you actually had the chance to question the police officer. That's why the officer was there in the first place. Or at least, Sherman Moore was supposed to have that opportunity. But as you mentioned, Sherman Moore is just a piece of paper. And here's the problem. Pieces of paper can't speak in court. They can't introduce themselves, and they certainly can't cross-examine witnesses. So clearly, this approach wasn't fully thought through, and the result was predictable. That brings us to the end of today's video. If anything new happens with this case, I'll be sure to update you. If you enjoyed the video, hit the like button. If it wasn't your thing, hit dislike, but don't forget to leave a comment sharing your thoughts. And make sure to subscribe with notifications turned on so you don't miss any of my future content.